Good afternoon, ladies and gentlemen. My name is Val Corbett from Independent College Dublin, where I lecture the law of torts and contract law. The purpose of today's session is to give a brief recap or overview of the law of torts upcoming examination paper. Unfortunately, for those of you tuning in expecting me to give the answers to the paper or predict exactly what's coming up, that's not going to happen. That's not the purpose of this session. What I would hope to do is have a brief overview, as I said earlier, of the actual main areas that tend to arise in this paper and point out specific issues that tend to crop up time and time again in relation to the examination paper. I will also refer to the last sitting of the examination paper, and hopefully by doing that rule out some of those topics maybe that you would place lesser priority on for this upcoming exam. So first of all, in terms of the tort paper or the tort syllabus, or perhaps maybe I should start from a general examination point of view and then focus on the specifics in relation to the tort paper. Firstly, going back on the past examiners' reports, which I'm sure most of you have read, there are a couple of issues that keep cropping up that the examiner is at this stage, I think, getting annoyed about, and maybe students need to start focusing and paying particular attention to them. The first issue relates to the very first point I made earlier on about trying to predict the examination paper and predict the type of questions that will arise. Of course, there has to be an element or a fundamental knowledge going into the examination, which you have to have learned. But one thing that the examiner has pointed out time and time again over recent years is the amount of students that go in with pre-prepared answers for the examination paper. In other words, the examiner seems to think, based on the papers that he's getting, that students are going in, let's say, covering defamation, for example, and no matter what kind of question comes up in defamation, the student is going to put down what he or she has learned and the exact format in which they've learned it. It is a big no-no with the examiner, and you can see that cropping up, as I said before, time and time again. So obviously, while you have to learn the information, and while there's an element of rote learning in terms of learning your cases and learning the principles and the statutes involved, you have to be flexible enough to be able to react to the questions that come up in the paper. So that just because the topic you've learned has come up in the paper doesn't necessarily mean you just vomit out the answer right there and then. This examination paper is a very much a practical focused examination paper, and that's to be expected given that these are entrance exams to the Law Society of Ireland in which you're training to become a solicitor, and solicitors will deal with real life problems every day, and what is being looked for primarily in these papers is practical advice, being able to identify issues, being able to apply that law to those particular issues and be able to conclude and give the client the advice that is required, the remedies that are available, or the problems or obstacles that may exist in relation to their potential claim. So the first thing I would say to you from the outset is do not go in with learned off answers. Go in, know your stuff, go into the paper and be prepared to react with what appears on the paper. So basically what the examiner seems to be focusing in on is the application of your knowledge as opposed to your knowledge itself. So again, if you want to score highly, of course, I would imagine what happens with a lot of students when they give these answers is that, you know, they're not that familiar with the specifics. And so the fallback position for them will be to give the answer that they've learned off. And come hell or high water, they're going to put that answer down on the paper no matter what the question is. Obviously, if a question comes up in the paper, you have no other alternative but to give a rote learned essay, well then, yes, it's a good fallback position because you may gain some marks for it. On the other hand, if you want to maximize your learning and maximize your marks, you need to be able to apply that law that you've learned to the facts of the question. So make sure when you're writing your answers, particularly to problem questions that arise in the paper, make sure they're tailored to the individual parties involved. In other words, if the question asks you to advise Mary in relation to her claim against Joe, make sure that in your answer it's peppered with references to Mary and references to Joe. So I would advise Joe in relation to the statement that the potential defamatory effect is as follows. Therefore, Mary's liability will be. That tells the examiner that not only have you learned the material, but you're also able to use that material and mold it into a proper answer and specifically cater it or tailor it to the needs of the examination paper in question. Another thing that I've noticed, again, from my own experience in correcting tort examination papers and from reading the examiner's reports as well, is do not repeat the facts of the question in your answer. Do not repeat the question. You will get absolutely no marks for doing that, and you will waste up precious and valuable time. So time and time again, you see students will rewrite the question in the opening paragraph of their paper, maybe trying to familiarize themselves or maybe find themselves more comfortable in their setting. But again, that's a pointless exercise. The examiner set the question, he knows what the question is, he knows what the facts of that question are, he doesn't want to see you regurgitate them. Obviously, if it's a problem question, you want to have a nice introduction of a couple of lines. If it's in relation to defamation, you might give a brief history of defamation law or the position of defamation law in Ireland, okay, before launching into the main part of the question. If it's an essay question, you're going to be asked to give more, analytical advice, and that's where extra reading, outside references to materials, and suggestions for reform will come into play. When it's a problem question, it's more practical advice in terms of, I advise Mary that the law is as follows, following the case of, or pursuant to the statute of, and so forth. Another issue again that rises is knowledge of statutory provisions. Tort law up until relatively recently, in the last maybe 15 or 20 years or so, was very much common law based. And so therefore you were heavily reliant on your case law. Body of precedent built up over the centuries and over the years to give you the principles that exist today. Very much like when you're studying contract law. It's virtually all case law precedent. In the last 10 or 15 years, as you've noticed, I'm sure, when you're going through your syllabus and you've been doing your study, is that there's been a raft of legislation that's coming into the realm of tort law. For example, you have the Occupiers Liability Act 1995, you have the Liability for Defective Products Act 1991, we currently have, well, whether it will see the light of day is another question, the Defamation Bill 2006, but so on and so forth. Increasingly, there's more statute law, legislative reform coming into tort law, and students have to be aware of this fact. The examiner has commented on it that while the case law and knowledge of the case law and principles has been quite good from students, their knowledge of statutory authority has been quite poor. So don't forget that issue. I can understand how it can occur because of the raft of case law that's built up over maybe a century or so. But recently, if you're looking at every one of your chapters, you will notice that there's legislative developments, Employers' Liability of the Safety, Health and Welfare at Work Act 2005 now, and so on. So have a knowledge of that material and also how it interacts with the common law position. Just a couple of things that you know yourselves from sitting past examination papers, but just to reference it more specifically towards law papers. Read the paper carefully. Again, it seems like obvious advice, but you could go into this exam, panic or be so nervous, you're keen to get the cases you've learned down on the paper, etc., whatever, you're keen to dive in and answer the question. The best advice in the world I can give you is spend 10 to 15 minutes, maybe 10 minutes, reading the paper from cover to cover at the very start of the examination. Don't panic. You'll see your colleagues and your mates and your friends either side of you onto their second booklet maybe after 10 minutes and they're writing furiously. You can't panic. You have to take your time, read through the questions and process what is being asked. The tort paper tends to be, maybe 60-40 in favor of problem questions. Sometimes it's 50-50. You get 50% essay questions, 50% problem questions. But you will probably have to do at least one problem question on the paper. And problem questions are going to be invented. You're never going to have come across the facts before in your life. You're never going to come across the names of the parties before in your life. It's going to take time. You read it the first time, nothing will strike you majorly. You might have a general idea, oh, this question is on defamation. You read through it a second time, and a third time, other issues should start coming to the fore and coming to your mind. It is worth your while doing that. There is nothing worse than ploughing into an examination question, spending 25 minutes writing the thing, or writing 10 pages on it, delighted with yourself, moving on to your next question, coming out of the exam, doing the post-mortem with your friend, which you should never do, but talking to your friend and say, oh, thank God that question on trespass to the person came up. I got my assault down, my battery down, my false imprisonment, etc. And your friend turns around and says, well, the question actually asked, discuss the defences to trespass to the person. Now that individual has written probably 6 pages on the actual torts themselves and maybe left a page at the end to the defences because they simply misread the question. It may seem right now, oh, that's a silly mistake, that would never happen to me. But when you're in the environment where there's heightened anxiety, you're nervous, the adrenaline is flowing, there is a danger that if you see an essay question and you see trespass to the person, as I said earlier, that you vomit out your answer. Be very careful. Essay questions on this paper do not ask, write all you know on. They never ask that.